It is my pleasure and privilege to call to order this meeting of the Dresden Board of Appeals. Let's stand and do the pledge of allegiance to our flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. To clarify our process for tonight, and I'm open to correction if I don't get this right. My understanding is that the members of the board tonight will deliberate over the appeal, that we already have received all the testimony from the attorneys and public comments, and apparently that public comment section of our deliberations is now closed. So we won't be entertaining any comments from all of you tonight. My apologies for that. It's just a legal process. So we are going to speak amongst one another in regard to this appeal, and hopefully we're going to be speaking loud enough that you'll be able to hear everything that we're saying. Please raise your hand if you're having difficulty hearing. I can always turn on my preacher voice, but hopefully I won't need to. All right, so we are here tonight to review the appeal of Barbara and Mike Flamini regarding MTN's application for the conditional use permit that was granted by the planning board. And our responsibility is to review, if I understand this right, review the work of the planning board and determine whether we think they were making their decisions within the parameters of the ordinances of the town of Dresden. Did I get that right?
You got it.
Okay. So thanks to the help of Mary, is that right?
That's correct.
Mary.
Great.
We have a Mary and Gray, I'm sorry. You weren't wearing a suit and a tie. I didn't know who you were tonight. We have a sort of an abstract here which lays out several key points. And we're going to go through them. Apparently, it might be useful to go through them, you know, in sequence and see where we are on various issues. Item number 4 on your page 3.
Page 3?
I think it's page 3, yeah, and top item number 4. So I'll read this so that everybody is aware of what we're considering. This says MTN's application site plan is or is not consistent with the goals and policies outlined in the comprehensive plan. MTN's application site plan is or is not compatible with the character of the neighborhood. That's our first question.
Mr. Chair, if I may.
Yes, please.
Interject here. I want to give a little guidance on comprehensive plan and your
Yes.
role there. So if you, let me try to find it in the planning board decision. There is case law out there, particularly, specifically, it's a Nestle's Waters case in Harvard.
Oh, yeah, I know that one.
You know, the Nestle Waters.
Yeah.
Well, in that case, the Superior Court actually sent it back for findings with the comprehensive plan. And somebody appealed, the Poland Springs appealed, and the law court for the state of Maine said a comprehensive plan is a planning document. It's a guidance document.
Not an ordinance.
It's not regulations. The zoning ordinance is what has teeth and what is enforceable. So if you conclude that a project is consistent with your zoning ordinance or your land use and development ordinance in this case, it inherently, ergo, it is consistent with the comprehensive plan because
Right.
your zoning ordinance has to be consistent with the comprehensive plan. The plan itself, the goals are too vague for anyone to think how can they be consistent or not. And so a court would not hold an applicant to that standard of separately complying with a comp plan. They need only be compliant with the ordinance. And I think the planning board found it's consistent. There it is. It's just the first. I'm on the planning board decision, page 3. Paragraph B. The board finds that the proposed activity conforms with a duly adopted ordinance and comprehensive plan and that the standard has been met. If it says The board notes that the town's land use ordinance has been adopted in conformance with the town's comprehensive plan.
Okay.
That's how they made that conclusion.
So we're not actually asking this question then?
It's been posed to you by the appellants. My advice to you is what the case law says, which is a comprehensive plan standard is not a separate standard for this board to review or the planning board. And therefore, if you went down the road of trying to figure out if this was compliant with the comprehensive plan, you might find yourself in legal trouble.
Yeah.
Kind of rule that number 4 is not enforceable. It's a comprehensive plan.
So the question is, I
Comprehensive.
mean, we pose these questions, but really it is, did the planning board err in its findings with relation to this question? And can I take a time out? Actually, I'm sorry. You have a new
Sure.
planning board member?
John is a
Board-
regular member of the
Right,
Board
right,
of
sorry,
Appeals.
but
Yes.
he was not here last week. so
Correct.
if You could just say your name and what
Oh,
you've done to
certainly.
prepare for tonight. I'm sorry, we should have done that.
Yeah, certainly. My name,
Just speak a little. Sure.
my
Yes.
name is John Medor. I missed the last meeting, but I did watch the whole video of the meeting. I've been part of the meetings all along. And I've been reading everything right up through, and like I said, I watched the video and I read the minutes that were supplied to me today, and so I'm attending this meeting.
Thank you. I just wanted to get, for the record, I just wanted to have that on the record.
Okay, fine.
Okay. So let's go back to this item number 4. Is it appropriate then for us to ask the question, is the site plan consistent with the ordinances of the town of Dresden?
The applicable ordinance.
The applicable ordinances of
Yeah.
the town of Dresden,
Yeah.
okay? And so let's deliberate that. We've looked at the ordinances and various portions of the ordinances, particularly this one asks about compatibility with the character of the neighborhood. So I think part of what's relevant there, at least in my opinion, would be this description of what constitutes appropriate activity in the rural living district in the ordinance.
Right.
And so you have all had a chance to review that, or would you need an extra copy of that? We've had many copies of it. You probably had it. I didn't
I
know.
have reviewed, it all, and, I personally feel that it doesn't fit in the rural living, because you can read the ordinances in
Speak up a little louder so they can.
in my opinion, I mean, if you read the ordinances, it says, minimal, impact and intended for rural resident and limited low intensity commercial. And if you look on the application taken out, it's got 2 categories for this application, minor or major. And it's checked off as major. So that, to me, doesn't fit in a rural
So-
residential.
I'm gonna have to interrupt just for a second, John, because you weren't here last week. Your job tonight is not a personal opinion. Your job tonight is what did the
Okay.
planning board do?
So I feel.
And so you want to look at what the planning board did on this question, review what they did and see if they made any errors.
Feel it made an error.
And you need to talk about what they found on this because and so you want to look at what the planning board found on this issue in regard to it being a permitted use.
Well, it sounds to me like they reached a conclusion which is different from the one John is describing.
But he's not talking about, he's not talking about what their conclusion was with regard to the use.
I don't understand
What I heard, their use is, if they filed under major, it's a major undertaking, not a minor, and therefore it doesn't fit in rural, and it's more of a, well, major business. where I feel they err in their decision.
Jeff, you have,
So, I mean, and I've did a lot of highlighting because that's how I get through things. And in my review of the documentation, we're talking about the process that MTN went through to fill out the paperwork to meet the requirements, and the board reviewed that. In the review of the board, and I agree that they found that it was in compliance with the ordinance. Based off in, their assessment and the fact that. Highlight too. And doing with, in that same page that she has, I even have it here, duly adopted ordinance and comprehensive plans and the standards that were met, and the standards. That they checked off met this, and so in my opinion. They did, if you're asking whether or not they are consistent with the goals and the policies outlined with comprehensive plan, then the answer is, for me, yes. In the process.
Lorna, your turn.
Okay, been helping here, Mary, but I'm also looking at,
Can you please speak up?
under, I'm looking at the ordinance under rural living and low intensity commercial, and I read a previous set of minutes, gave an example of a tattoo parlor. And I thought that met low intensity commercial, just for an example of something that I felt was appropriate, and just rural living, I'm quiet, peaceful town, I'm struggling to feel how that meets it, and this is where there were just some additional things.
Yeah, I just want to point out that this particular use, extractive activity, is permitted in the zone.
Okay.
In your ordinance, as a conditional use.
All right.
So that's,
I disagree with that.
it's extractive activities in your,
Extractive activity, but not specifically the quarry.
I'm just pointing out
Yes.
for your purpose, because you're talking about that this isn't a tattoo parlor, so I just want to help your conversation by pointing out that extractive activity is permitted use, so if you could
Granted.
talk about how you feel, like why it doesn't meet that is more helpful,
Okay. Well, some of my
or it
concerns.
does or doesn't, whatever.
Yeah,
your
well, some of
decision.
my concerns is that the evidence has been presented that the operation of gravel pits within rural districts has been permitted in the past here in Dresden, and that's going on today. So that's not necessarily what we're debating, but I think the fact that it is a quarry that will involve blasting and crushing raises it to a different level than just all the other extractive activities that we are comparing it with. And, you know, my concern is that the planning board did not appropriately interpret this ordinance when they granted the conditional permit, because it doesn't meet the criteria of limited low intensity commercial, where a gravel pit might meet that criteria. I would say the blasting of a quarry does not qualify as low intensity. So I would disagree with the planning board's decision, or say they were in error when they interpreted this ordinance in that way. That's me. Go ahead, John, and then
Well,
we'll come right back to you.
I'd like to speak, since the question is about comprehensive goals and policies. If you look right in the state of Maine, because it's a question about comprehensive plan. If I can find it, I got it remembered here. It's hard to flip this book, but it's on pages 137, 141, 143, and 213. And it's guidelines, which it's a question about guidelines. For municipalities, it's a state telling municipalities how to guide this is on rural living. And this pertaining to this question, it doesn't follow the state guideline. I know the guideline, but it's a question of the comprehensive plan, that's what's.
I'm sorry, I'm only interjecting to try to guide your decision in a way that the framework is a legal framework. And so the framework you're working under is your own ordinance and not state law.
So, and I wanted to add to that.
Yes.
We're not here. My understanding is we're not here to deliberate whether or not the ordinances or the comprehensive plan are 100% in line with the way it should be written for the way people feel that it should be written. And we're not here to deliberate that. We're not here to put our feet in the planning board's shoes to see if, to make a judgment on whether or not the planning board, as if we're the ones making the decision. We're here to see if that process that they have written out in a business coming in and saying, hey, I'd like to open a business. Here's the application. I think I filled it all out. The planning board goes through their steps based off of the ordinances that they are outlined in front of them. Whether or not they're, and I think that's what the whole moratorium in the future is about, is the fact that it doesn't meet that. But for now, we're looking at the application that was put in front of the planning board when they made the decisions, and whether or not they violated something major in the ordinance or the process to come to the decision. And for me, based off in, the extractive industry and permitted under activity that is permitted under Article 5 of the ordinance pursuant of the constitutional use of the permanent agreement, and this rural living district and the definition, we're not here to define that definition or to, well, could it have been or not? Were they within the process? Did they look at the application? Did they look at the ordinance? Did everything meet when they accepted the final thing? And
Yeah.
that's where we're at.
Okay.
And to me, I think the MTM went through the process, the board went through their decision, and they came up with, yes, they meet that criteria. And we're looking to see if anything out of the ordinary happened that wasn't covered. And I don't think it did, but so in my opinion, MTM made the application and sufficed the evidence that they needed to move it forward. That's just my opinion, my
Okay.
research.
Okay, thank you. Lorna.
I Googled what a quarry and gravel pit is. And under quarry, it says use of explosive drilling and heavy machinery for the quarry. And I say that because I can't feel that fits into rural living. And the other thing is that I think further investigation, upon reading all this, it seems like there were numerous things that should have been looked at, such as I saw nothing that, something about the town of Woolwich told the town of Dresden to take this slow. There's a quarry in Hollowell. Sort of looking at other towns and what they learned, lessons learned. So I'm still really struggling that this meets the intent of rural living.
Yeah,
So
and I hear.
I'm
give
gonna
me-
have to
give-
interject.
Just,
Okay.
Yeah.
all right, just give me a moment.
Fine.
I know that you're concerned that we're expressing personal opinions.
I'm concerned that you're not looking at the site plan standards
Yeah.
in your discussion. You're only talking about more of a broad, you're actually having a comprehensive plan discussion as to whether this is consistent with this use is consistent with the plan, as opposed to whether this application meets the standards of the site plan ordinance.
Well, see, I see that a little differently. I'm reading the land use requirement ordinance. And my conclusion is when the planning board granted this conditional use permit, they erred because they did not comply with the rural living district ordinance as I read it.
So, but they applied for a site plan approval. And so you have to look at the site plan conditions to see the review criteria. And that's the decision criteria that you're reviewing. is the site plan review
But
criteria.
I find their decision process faulty because it didn't comply with the ordinance. How can we do that?
So
I mean, they looked at the ordinance and they developed the site plan and they did the site plan and all that, but they never attended to the fact that one of the phrases in this ordinance did not fit with the,
So they
with the
made,
permit.
they made a conclusion under site plan criteria that it met the site plan criteria.
Well, that's great, but what about the ordinance?
Excuse me, including, compatibility with the neighborhood and other standards.
Uh-huh.
So if you go through those standards, as opposed to just generally saying that you don't think this is a use that's allowed in that zone, when it is a use that's in the table, I would just recommend that you make your decision couched in the actual decision criteria for site plan application.
I'm not sure how we're supposed to do that. I just don't understand that. As soon as the application was made, I think the planning board should have read this and said,
I'm just advising you, if you
I
want to
hear
write a
you.
decision that says you
I
don't
hear you.
think this use is allowed, then.
no, we want to do this right. But I mean, what exactly is the right process?
We could answer the same thing in the last question.
Go right ahead.
Well, the last question is, the planning board did not err, sorry to jump, but erred by concluding certain standards in the ordinance were inapplicable to MTN applications, specifically pollution, specifically. I was thinking you generalized, but
Mhm.
specifically, all these other questions down through here are just, did they meet DEP, did they meet, yeah, they did meet. I totally agree, they did with you, Jeff, they met a lot of them, got a lot of, but they're not, all these agencies, I'm sorry to say, and that part of this ordinance of rural living is these agencies that approved it, aren't living next to it. And I'm just want to furthermore, is just going on with the rural living that we're going, the ordinance. Is the fact that it devalues not only the traffic beats, but anyway, it devalues the neighborhood. And that's what the ordinance is on, maintaining neighborhoods and rural living. And so therefore,
So we're having,
these questions are just.
we're having a little bit of a debate about the spirit of the ordinance versus the actual words of the ordinance. I think we may have opinions, but I think we're trying to do something legal here where we look at the ordinance and we look at what the planning board did and say, were they in compliance with the ordinance?
And appendix A of the town's ordinance defines extractive industries as an activity process involving the extraction of land, borrow, topsoil, clay, rock quarries, and the processing and borrowing pit materials. Now, again, when the planning board reviewed their own ordinances, this falls in that category. So did they meet compliance?
Yeah.
They were not, that has, as a business in the extraction for the town ordinance for this, they've identified it. They put their application forward as a major, which is followed right here on the site plan review. The application went through. They felt that it met the criteria for our ordinances. It wasn't, and so in my.
Yep.
Again, I don't know that I'm not budging off in what, the MTM made the appropriate, because we're only here to look at the process.
Right.
How they got to where they got to. And so I'm
Another,
not here to deliberate whether or not, what the definition of rural resident, because that's not part of my function. So
Okay.
I appreciate it though.
thank you. I think just as another observation, and that would be, that's part of, I think that's playing into this here, is that there's just that one tiny little appendix line that makes a reference to quarry. The ordinances of the town of Dresden really do not provide any guidance on how to operate the quarry in Dresden. That is not here. We haven't have we had a quarry here in Dresden before? I don't know the answer to that question, but I don't think so. In which case, we're into some new territory here, and I think the land use requirements don't sufficiently address all the issues that would be associated with the operation of quarries. So would it be possible for MTN to make an application for the operation of the quarry and assure us that it was a limited low intensity operation?
So I'm gonna sound repetitive, but your ordinance is drafted in a way that allows extractive activities in that zone. Extractive activities is defined as, and it's just read, an activity or process involving the extraction of land for borrowed topsoil, clay, rock quarries, and the processing of borrowed pit materials. That activity is permitted in that zone. The conversation you're having right now, to me, feels like a conversation as to whether you disagree or agree with the fact that that activity is permitted in that zone. It, as drafted, it's permitted, and there are standards in site plan that talk about extractive activities, and those standards were discussed in the appeal, such as groundwater. There's specific standards for extractive activities. So that's why I'm trying to guide your decision to the site plan criteria as opposed to questioning whether it's allowed, because it is allowed under your ordinance.
Could we say it's allowed under our ordinance if it meets the criteria of being a low intensity operation? That's written directly into the ordinance.
No.
Well, that doesn't make any sense. How can we have an
When
ordinance?
the ordinance was approved at town meeting said that use is allowed in that zone. It doesn't say that use with an asterisk as long as it's low. That this is the way the use is defined. It says rock quarry, it's in your ordinance as written. If you, and that's, things come up when there's applications and you realize, wow, it's written that way, and the way to change it is to change your ordinance, not say, sorry, we didn't mean that that's allowed here. There's the ability for someone to apply. That's why I'm trying to gear you towards the site plan standards, because the fact that it's an allowed use gets the foot in the door, and then they have to apply for a site plan approval, and that's what the planning board went through, those standards. And that's how the arguments would couch in those standards.
Intensity, but when I read the definition of whatever I said there, explosive drilling and heavy machinery, I'm hard pressed how it could be low intensity.
But we're not, that's not we're not here to put our feet in the planning board. We're here to say, did they meet the criteria based off in the site plan evaluation permit application? And whether or not they followed the process to get the application approved. And, you know, we can debate that, but it's irrelevant because we're debating the process. Was it done correctly? So, I mean, we can sit there and think that they might have thought this way, but they didn't specify it. You know, that's why this whole moratorium in the future is coming up.
Is law a matter of interpretation?
Not when you have a definition that says rock quarry is kind of permitted use in the table. You can try to interpret it a different way. I'm trying my best to try to direct you to a decision that would be upheld in the event it was appealed.
Is anybody here moving in terms of their understanding of this issue and how
I
to?
think further research should have been done.
I'm trying to get them to the criteria and then we'll discuss it.
Okay, well, it seems at this point we have a somewhat of a disagreement as to how we're going to proceed.
So if I may, I know I think it will make sense if you just kind of get past you don't think it's allowed, period, and then start going through the decision criteria that have been brought up. The first criteria is something that you started talking about, but it sort of got mixed up in the conversation. of
Refresh my memory.
Compatibility, so there's a standard.
Yeah.
Is it compatible with the character of the neighborhood?
Yeah.
That is an appropriate discussion to have about this proposal, because it's actually a site plan standard. And if you want to pull out the standard, review the standard and have that conversation, it appears that that might be the right place for your discussion. So it's in number 4. So the Ferminis made 2 initial claims, arguments. One is that it was not consistent with the comprehensive plan, and we already talked about that.
Right.
And the other, in that same argument, was that it's not consistent, that the planning board erred in finding that it was compatible with the neighborhood. And so there's a standard in site plan, compatibility with the neighborhood. And it is L, I think, off the top of my head, I need to pull out the right. So if you look at was that yeah, there's 3 in that L, in that, or maybe.
Getting lost in the weeds here. Yeah.
But,
So neighborhood compatibility, it's actually K, it's on look at page 6 of the planning board decision, and you can see what they did, but that lays out the standards.
Oh, thank you, thank you. Where are my lookies?
Neighborhood compatibility.
Page 6, yeah.
Neighborhood
Neighborhood
compatibility.
compatibility. Item number K.
So I really should not be doing this much talking, but I do need to help you here as well. I need to just caution. This is just a caution, which is there is other case law out there about some of these, not all of these standards, some of these standards being unconstitutional. Something along the lines of just safe and healthful, something that's not objective. So I would stick to the more objective standards within this discussion. That's really the advice I can give with regard to that.
So when the planning board said 150 feet of woods and a natural berm meets the criteria for maintaining the standards of the neighborhood, could we disagree with that?
So you have to find that they erred in their application of this standard. So not that you disagree.
Maintaining the character of
Not
the
that you
neighborhood.
disagree with the conclusion that they made, but whether the information provided to them, whether they made an error of law in making that conclusion that it was consistent based on that standard.
So where it says the proposed activity will be compatible and sensitive to the character of the site and neighborhood relative to land use, scale, bulk, and building heights, neighborhood identity, and historical character and orientation on lot.
Mhm.
So that's the law?
That is the standard in your ordinance, yes.
Okay.
Yeah, that's
So,
correct.
so we might conclude the planning board was in error when they said they're in compliance
could-
with that law,
You could conclude that, yeah.
because we don't feel like they have
You could.
taken
you
into
could come
account
to that conclusion.
the full impact of the character of the neighborhood that this project
You'd have to-
creates.
And then you'd have to talk about what facts and evidence that was presented in the record that support your decision and don't support the planning board's decision.
Okay. Yes, I'm kind of stuck. Oh,
I'm in agreement with you.
uh-huh.
John, you're wrong.
Okay, so, so it looks like we're gonna have a 3-to-1, on this particular issue. And if that's the way we go, we're gonna face some problems in court. And so maybe the courts will sort it out. Eventually, the next step might be that if the courts find that we erred in our decision,
We're doing it in good faith.
I know you guys are going crazy out there because you want your opinion, and I'm sorry, this is just the way it's structured tonight.
Okay.
All right, so, are we going to vote on each one of these items like this? And how we deal with it. So this is item number 4. So I would say the question before us is the application site plan compatible with the character of the neighborhood? I would vote no. Mhm. You would vote yes, and you would vote no. So the vote is 3-1 on that one.
And can you give the records an explanation as to how you came to that conclusion based on the standards in the ordinance?
And I'll let John do that.
Yeah, no, after reading the material, I've gone through everything here, and it just is. Even down to the application being major X, that really struck me pretty, not minor, but major. Secondly, another point of the town of Woolwich is expressing concern over this also. They've written a letter to our town, and they're not favorable.
But that's not our deal.
No, but I mean, it's evident
It's something.
that's been.
It's doing the
presented to us.
resourcing. Figure-
Yeah, it's
Pulling
evidence that's been
information.
prepared to us.
And I think it's
Okay.
And
helpful.
so, I've had to read everything, and these things come back to me.
Yeah.
And, that largely everything else, but those two and the guidelines, I'm sorry, they're guidelines, but they were meant for a purpose. That's my decision.
So you're saying when they identify this as a major project,
Major.
that they were then in error in granting the permit because major would not, it would not.
It's not low intensity, it's major.
Major is different from low intensity.
I would assume, I
It's-
can't.
I know the assumption it's not, just for your information. Site plan is divided into two categories, minor and major. And whether you fit into minor or major is just a difference of the level of review. It's not intensity of project. It's not related.
You know, and I'm only gonna address my side on it. Again, I'm reiterating what I've already said before. We're here to evaluate whether or not they followed the ordinances that were already in place, that our town already put forward, not to put our feet in the planning board and making that decision. The decisions we make tonight, whether it gets kicked back down to the planning board or up to the courts, is gonna cost us town money. And, so we're talking about the application process. Did they fill the application process out correctly? And yes, we can sit here but when you look through the criteria, what they asked to meet and what their evidence that they supported, and then reading the findings, they didn't violate anything in our own ordinance or a site plan application request. I think that by putting too much of our personal interpretations of reading it, we're not doing the justice of whether or not the process was done correctly. We're not looking at, we're too busy looking in the weeds of what they think or what we think. It's what did the application ask them to do? Did they provide it? And so if we're gonna go through the rest of these articles with that same process of, well, I don't know if they met this, or we're gonna end up causing this town a whole lot of court money. And when we're just here to evaluate the process that it took to get to an approved application to the planning board. Okay.
And I think it's incomplete. I think not trying to, in hindsight, we can all look at different things. I think there's a lot more that should have been done before the planning board ever process it to meet all the ordinance.
But we are an appellate appeals board where we're evaluating the process, not put our feet That's a no, what was it, a no-val, no,
To know.
de novo type of appeal board. We're not that, we're an appellate board, where we review the process. We're dipping our toes in the
To know about.
yeah, there you go. I'll get it right eventually. We're too busy dipping our feet back and forth into that. We need to stay in the process of
If the
appellate.
process feels incomplete, I don't, or is that semantics on words?
But I wanna keep them.
Yeah, I know.
All right, next one.
Well, you know, and the appeal that the Ferminis are making is that the planning board did not fully assess the impact that it was gonna have on the neighborhood. Whatever they documented here in these papers, the Ferminis are saying that was an insufficient process because it did not fully evaluate the impact of this project on the neighborhood, namely the next door neighbor. Is that legal to say that?
What you want to go through is I guided you to the actual standard. The compatibility of the neighborhood. And what the planning board found, and as you asked and I answered, you can find that they erred in that conclusion, if that is the direction you are headed, but it should be in that context of the actual standard that is in your ordinance. And so if you want to read that standard, is in that planning board decision that you were just reading, so it has 3 parts. So I would recommend that when you're talking about that you found that it's not compatible with the neighborhood, that you couch your decision within the actual standards that are in your ordinance.
Standards, number 1, proposed activity will be compatible and sensitive to the character of the site and neighborhood relative to the land use, scale, bulk, building height, neighborhood identity, and historical character and orientation on the lot.
Yeah, I would say,
Standard 2,
wait a minute. I would say they erred in interpreting that standard.
Okay.
They did not interpret that standard adequately. They did not do enough of a job in investigating what the impact was going to be on the neighborhood.
Okay.
And so I think they were in error.
And I will second what Paul just said, that
All right, and are you there? Okay.
all right.
So we
we're on
have,
5.
so we have a 3-1 vote on that article. Now we're going to the next one. Did MTN application was or was not complete following its withdrawal of the Maine Department of Environmental Protection placard? And I would say it was complete because that thing was, it was not germane. They were required to get a new placard.
Yeah,
So I don't think
I support that.
I don't think that application was incomplete because the previous placard had been withdrawn. I think that was done appropriately. You're in agreement with that?
Yes.
How about you,
Yeah.
Jeff? Okay, so we're all in agreement on that one. All right, the next item, MTN did or did not comply with Article 6, Section 7E9 of the zoning ordinance requiring that they submit evidence of applicable state applications or permits which have been or may be issued. Again, I think the word conditional in the granting of the permit was that this permit will be valid once all of those other conditions have been satisfied. So the application didn't require that all of those standards be met before the permit was granted, but it would have to be met before the operation could begin. Am I making myself clear? In other words, they granted the permit and said, but you're gonna have to comply with everything the state and the DEP have. You know, that's conditional. So I think they were in compliance there. All right, everybody in agreement on that? Okay, democratic process here. Item number 8, the planning board did or did not err in failing to make factual findings about the impact on protected critical habitat and water quality standards in the eastern or Kennebec rivers or the Necrossic Brook. I really didn't understand well enough all of the details associated with that.
No, okay.
and water quality, I mean, my concern really is all the wells, not the aquatic, the water system, but the wells surrounding. so
No, they didn't air, they, on that factual findings about the impact, because they had all the documentation about Kennebec.
Yeah.
Eastern, and everything to do with water.
Are you satisfied with what they did?
Yeah, I am.
yeah.
I mean, they.
I am too. You are too? Okay. All right, next item, the planning board did or did not err by not requiring evidence as to the quarry's impact on the Kennebec estuary focus area or the scenic or natural beauty of the area. And I think the same criteria that we used for the previous two questions, I would say apply here as well.
Yeah, I agree with
You in agreement with that?
that. Yeah, they.
Lorna's got a, peptic ulcer on
Yeah,
her face.
well, I'm struggling over the natural beauty,
Natural beauty.
right?
But to go to Jeff's point, did they look into it and reach an appropriate conclusion that the
Okay.
natural beauty was gonna be protected? I think that's, I'm starting to turn into a lawyer here. All right, so are we in agreement with that one?
Yep.
All right, so we're up to item number 10, and for your information, we only have 11 items, so we're nearly done. Number 10, the application did or did not meet the appropriate standards, or did we do this one already?
No, it's a different
All right,
question.
appropriate standards with regard to the Kennebec estuary focus area, water quality degradation and pollution, and the planning board's findings in these areas were supported by substantial evidence.
They put a lot of paperwork regarding, yeah.
They sure did, they
regarding
sure did.
this.
It looked like these areas were thoroughly investigated, you know, might not have reached the same conclusion, but they, I think they did their job well when they did that.
Yeah,
Okay,
so they did, yeah, for the application, we met the appropriate standards with regard to kind of that, that's very focused area. And we did read it.
and then the last item is the planning board did or did not err by concluding certain standards in the ordinance were inapplicable to MTN's application, specifically pollution and reclamation standards. The planning board did or did not err by concluding certain standards in the ordinance were inapplicable to MTN's application regarding pollution and reclamation standards.
What?
I need help with that. That's,
So,
go ahead, Jeff, you seem to understand this well.
so the ordinance set forth, in their, ordinance. Ordinance set forth and then there's. Fine activity. Must not undo. Okay. The activity must not result in undue water or air pollution. Despite the environmental concerns related to the proposed project, planning bay made no factual, that's the Fermanis,
Their claim,
their claim.
right?
The.
What were the standards in the ordinance that they considered
All right.
inapplicable?
The planning board found that based on the board's interpretation of the scope of the subsection, that the board finds that the subsection applies only to borrow pit and topsoil mining operations, not quarries, for the reason the board had found this inapplicable. So we're talking about the,
This is about pollution and reclamation.
right, this is,
Let me ask you this, Jeff. Do you think what they were saying was, we have ordinances that apply to gravel pits and they must be concerned with pollution and reclamation?
yeah,
But
let me
this
just
part-
read the standards, make sure that we're
Okay.
within the.
Yeah.
We're within the application, so I have everything tabbed, but not everything written. So if that makes sense.
When we're done with this, I want you to become my personal attorney.
Don't want that, you may go to jail.
This is being recorded.
Well, I'm not a good lawyer. All right, apologize, I'm just,
Go right
I
ahead.
have it all.
Take your time.
Yeah, Jeff, at least you're able to do it.
Yeah, I appreciate the work you've done.
Just trying to find the actual language on, pollution, all right, the standard. The, which is underneath, and for those that are following along, the site, plan review and conditional approval findings from the planning board. This is page 6 under pollution standard. The proposed activity will not result in undue water, air pollution, and marking the determination the planning board shall at least consider, and those are the things. The elevation of the land above the sea level in relation to the flooded plains, which we don't have that. The nature of soils and subsoils and their ability to adequately support waste disposal, which they're draining, because that's what they put in here. That's part of their application that they went through. The applicable state and local health and water resources regulations are, these are the standards. The impact of the phosphorus export and the pollutants. Now, the evidence that was presented to the board was the board reviewed the substantial evidence provided underneath this specific. Specifically, the board noted that it understands that these standards was intended to germane any proposed septic system, none of which are proposed, and the evaluation of the site based on the board's own observation as well above the sea level. So based off in the fact that this initial standard was for septic systems and not necessarily for it doesn't constitute being a violation. They didn't air it in there.
We just suggest we keep reading. You read evidence, read findings. Just
Oh,
for
findings, yeah.
information.
The board finds that the standard applies to the application proposing subsurface wastewater disposal systems, which are not being proposed here, so that the standards are inapplicable to the extent that the standards applied to this project, the standards have been met. And, you know, it's funny, I had it highlighted, just got to read it. So I'm saying that they did not.
So we're saying, that when the planning board concluded that that ordinance did not apply here, they were saying that ordinance was intended to be about septic systems, and that's why they're not applying it here.
And
that's
or
very
above
simple.
sea level.
And the simplified version.
Right.
What do you all think of that? I'm concerned about pollution and reclamation. You know, is that irrelevant to the operation of this operation or that particular ordinance? Is there another ordinance, or did they already have another ordinance where they addressed pollution concerns and reclamation concerns?
They did address recreation concerns, but in a
In a
different,
different section.
but it was in reference to topsoil and borrowed pits. Because like, for instance, if I go and pull all the dirt and soil out of an area and I just leave it as one big hole, the reclamation didn't take place. But in a quarry, you're taking out rock. You're not gonna have anything grow back on top of the rock. Nothing was growing on the rocks to begin with.
But there is a legal requirement for reclamation. I believe we were told,
Yes,
because the project was in, I think, 10-acre segments, that before a second 10 acres could be begun to be mined, the first section had to be entirely reclaimed.
Yeah, and I'll read you.
That's discussed on page 11 of the planning board decision. It's underneath the erosion standard that they talk about.
Let's see, I had it.
So what should we say about that?
It's helping you get that. Because I can word search here. You can't.
You think they were in compliance?
I know, doing it hardcore.
Yeah,
I really don't get it.
well, polluting anything around it,
Yeah.
polluting from the equipment, they got all documentations. That they have the plans in place
Okay.
for this, and,
So we're concluding they did not err
Correct.
when they did not apply this ordinance. Is that what we're saying?
yeah,
Although the ordinance applies to gravel pits? but it doesn't apply to this thing?
No, we're not, that's,
And I'm just asking a
Yeah.
question. Is that ordinance applicable to a gravel pit operation, but not to this operation?
No, what they presented was evidence that their project isn't gonna be
Correct.
polluting.
Okay,
And, you know, it's not to do with, you know, what the ordinance says, it's their project, they proved that they met.
they did that in another place.
Right.
All right.
No, they did it here, they had it, you know, studies done.
Uh-huh. All right, so, how do we vote on, did they err in their conclusion?
I'm saying no.
Jeff is saying no,
Didn't know.
they did not. Okay, I
I
would
think
agree
they
with that.
provide, yeah, it is, I'm not saying, they did provide.
Okay. So as a summary, we have concluded that they were in compliance with all of the issues that were outlined here, that were part of the Fermini appeal, except the first one about compatibility with the character of the neighborhood. And on that point, we have disagreed and said that the planning board did err in that conclusion. Is that correct?
Yes.
Yeah.
Do we all understand that to be the case? All right, now how do we make that decision sort of officially official?
So you would want to pose a motion
Okay,
that the board grant the appeal.
all right. On
Because
that
it
one point,
finds that the planning board erred
on that
in
one.
finding that the site plan application
Okay.
Was compliant with.
Be-
all-
Before we make that motion, what would be the outcome of such a motion if it were passed by us?
The outcome is
The-
that
If the
you,
appeal is granted, what does that
the
mean?
appeal is granted, meaning that they did not demonstrate that they don't get,
Okay, and what happens next?
it's up to MTN, they want to do next.
Okay. Now, do we all understand that? We're not necessarily sending it back to the planning board?
No, you're not.
We're not. Okay,
Mm-hmm.
all right. So who would like to propose a motion? Probably not Jeff.
No. I'll propose a motion that we, after reviewing, I was gonna say remand it back, but we. How would
Make it simple because it's
on the ground with the,
granting the appeal
yeah,
on the basis of.
Help us, Mary.
yeah,
What does John want to say?
You want to say that you move to grant the appeal,
okay, yeah, grant the appeal to stop the,
you want to grant the appeal because
I
you
feel the
found,
planning board.
No, don't say I feel.
No.
because the planning board erred in its decision. Specifically, the planning board erred in finding that the proposed activity would be compliant with the character of the neighborhood, site plan standard, paragraph L.
Is that what you just said?
Okay, okay.
All right,
I have,
that's been moved.
I made a motion.
Is there a second? Lorna seconds the motion. Now we'll put it to a vote. All those, any further discussion before we vote? Jeff, any last words? Same thing. Okay, you've made your position clear and it's good that you did. All right, all those in favor of passing this motion, say aye. Aye. Those opposed? All right, so the vote is 3-1. The decision, the motion is carried. Does that conclude our work for tonight? All right, I will entertain a motion. I will entertain a motion to adjourn. Well, somebody has to move it.
Oh.
Record issue. I don't know.
I second it.
All right, all those in favor of adjourning, say aye.
Sorry, I just want to make sure,
Oh,
if there is an actual issue, I
Yeah.
want us to be in a place, I don't know, but
We could be on, I guess if we could just be on the record, maybe we could do it after they vote on the. I mean, they voted on it now.
Yeah,
The issue is that we didn't get any proposed findings until tonight. The evidence before the board was not complete compared to all of the evidence that was actually presented to the planning board. There were additional documents that were presented
all
to
right,
the
well,
planning. board.
we're
We
gonna
can deal
write
with
up
that after.
findings, we can
Right.
deal with that after.
Right, that's fine.
Okay, that's fine.
all right, so we're ready to adjourn?
Yeah, I would just say for the record, this was just a draft to help you work
It
through.
was very helpful.
To
Thank
the
you.
extent the attorneys have any comments on things that are missing from this, we can email, we can come up with a final draft for the board's adoption at your next meeting.
Oh, we have to have another meeting?
Well,
I don't want another meeting.
you don't really need that,
Thank you.
I guess, I mean, what you can say, so let's not adjourn.
All right.
And let's vote to allow authorize the chair to sign a final findings of fact that the attorneys draft in accordance with the findings that you made tonight, and that's sufficient, because we have it already.
We're gonna stay on. So what is it we're gonna be doing?
I think we're not
You're
gonna,
authorizing him to sign this.
authorize me to sign the final record of the motion we made tonight. But the legals have to craft it.
Oh, so.
I made the motion, you authorize
Yeah,
the findings.
you're willing? Okay,
He's not consecutive.
all right. All in favor, say aye. Aye. Okay, and so we are suspending or we are adjourning?
You're adjourned.
All right, well, let's vote on adjourning. I don't.
Okay, yeah.
All those in favor of adjourning, say aye.
Aye,
Those opposed?
we're getting it, so.
Meeting is adjourned. Thank you all very much.